This meeting will come to order. This is a public meeting of the U.S. Commodity Futures Trading Commission. Let me welcome my fellow commissioners, their staffs, agency staff, and interested members of the public. Thank you for your engagement in this important regulatory process. We have two matters before us today. I look forward to the staff presentations on each of them and their thorough consideration and disposition by the Commission. There was another matter that was noticed for this meeting, a joint proposal with the SEC to align the minimum margin required on security futures with other similar financial products. That matter was unanimously actioned by seriatim and was announced earlier this week, and I thank the commissioners and their staffs for its timely handling. Before turning to today's business, I want to briefly address some idle speculation of late in the London press regarding my supposed candidacy for the position of Governor of the Bank of England, the UK's central bank and prudential regulator. As I inform my fellow commissioners, I have neither sought nor applied for that position, for which I understand the application process formally closed some time ago. And more broadly, I confirm that I have not, and I will not, discuss, consider, apply for, or pursue any professional engagement or employment of any kind whatsoever, either here or abroad, until after the full completion of my service on the Commission. Now, I mention this only to dispel any concerns that such press chatter may suggest about my engagement in today's proceedings, or for that matter, any other subject now before the Commission. Turning to the matters at hand. The CFTC has been a consistent leader of the world's major market regulators in enacting effective derivatives regulation and oversight. By 2014, it was the first regulatory agency to implement most of the internationally agreed swaps market reforms. As a result, the CFTC now has more than 5 years of experience with its current regulatory framework, including its approach to cross-border application of its rules. This puts us in a position to assess that application's different strengths and shortcomings. Based upon a careful analysis of the data and our experience, it's possible to recognize successes, address flaws, recalibrate imprecision, and optimize the underlying measures. And this is particularly important with respect to the CFTC's approach to regulating cross-border derivative activities. Last October, I published a white paper on cross-border swaps regulation. It proposed updating our current cross-border approach with an objective and risk-based framework, one based upon regulatory deference to third country jurisdictions with comparable regulation and supervision, including those that have adopted the core G20 swaps reforms. Stemming from that white paper, the staff has put into seriatim over the past several months 4 proposals on the cross-border reach of CFTC derivatives regulation. The first proposal was unanimously approved by the Commission several weeks ago. It establishes amendments to certain provisions of CFTC regulations governing the offer and sale of foreign futures and options to customers located in the United States. The proposed amendments would codify the process by which the Commission may terminate exemptive relief issued pursuant to those regulations. The next 2 proposals deal with issues related to the registration of derivatives clearing organizations, and they are the subject of today's open meeting, which we will turn to shortly. The fourth proposal concerns the registration and regulation of swap dealers and major swap participants. This proposal continues to be the subject of constructive dialogue within the Commission and with the Commissioner staffs. It remains before the Commission for consideration in seriatim, and I commend that proposal to my fellow Commissioners and my successor as Chairman for their thoughtful consideration and advancement. Before turning the microphone over to my fellow Commissioners, I want to acknowledge that these proposals have absorbed enormous time and attention from them and their personal staffs. The divisions have received excellent comments and engaged in extensive dialogue with each Commissioner office. Whatever the final disposition of today's proposals, I want to acknowledge that each of the proposals has benefited from the intelligence and bipartisan attention of my colleagues and their staffs. And I also want to thank the agency staff for their fine work and input, especially the Division of Clearing and Risk and the Office of International Affairs. These hearings require extensive preparation by them, for which we are very grateful. And I want to thank my own staff, especially Matt Dagler, who has devoted so much of his time to seeing these proposals through. And finally, if you'll allow me, I want to publicly acknowledge my gratitude to Mike Gill, who is simply the finest, immensely capable, and most effective Chief of Staff and Agency COO in the federal government. Mike managed my transition to the Chairman's office and will assist Dr. Tarbert with his. I'm deeply indebted to Mike Gill for his matchless savoir-faire. I now recognize Commissioner Quintens for his opening remarks.
Thank you, Mr. Chairman. Thank you for calling this open meeting the last open meeting of your chairmanship. But more importantly, thank you for lending your invaluable expertise and your voice to this agency during your tenure here, first as a commissioner and then as our chairman. Let me just say I've been consistently impressed and inspired by your commitment to thoughtful public policy, your willingness to consider alternative viewpoints, and your unwavering dedication to the success and well-being of the U.S. derivatives markets, as well as to this agency in particular and its employees. Your tenure here will be long admired, and you personally will be very favorably remembered and sorely missed. I'm pleased to support both of today's proposals, which embrace a view of global swaps market regulation based on open competition and choice, deference to comparable foreign jurisdictions, and cooperation with our foreign counterparts. I would also like to note that today's two rules are part of a multi-pronged approach to right-size the CFTC's extraterritorial application of its regulations. The last piece, on the regulation of foreign entities' swaps activities, is still being considered and actively discussed. I very much look forward to the Commission considering a proposal on this important topic that takes a similar view towards foreign deference in the near future. That comprehensive vision of deference was fully laid out almost one whole year ago with the Chairman's release of his cross-border white paper. I'm very pleased that the Chairman, through his leadership, and the staff, through their great and tireless work, have been able to put the first steps of that cross-border vision in front of us today, and to finally, after 9 years, put some meat on the bone around 2I and what constitutes a direct and significant connection to activities in the United States or effect on commerce of the United States that would necessitate the application of our rules abroad. Thank you, Mr. Chairman.
Thank you, Commissioner Quintens. Commissioner Benham.
Thanks, Mr. Chairman. First off to you, thank you for your leadership and your service. Thanks for calling this meeting. Echo a lot of the things that Commissioner Quintens said, and you will be missed, but we appreciate all the work you've done for us. Thanks to the staff who did all of the tireless work. Mr. Chairman, you said this appropriately. It's interesting time following a holiday week to have a meeting, so there was a lot of work that had to get done around holidays and vacations, but I do want to thank all of you for the tireless work you've done working with my staff and getting these documents to the place they are today. These are certainly important rules, and I look forward to discussing them and asking questions and hearing responses as well. Our international presence is obviously significant, and as we move further and further away from the financial crisis and Dodd-Frank, markets are changing, rules across jurisdictions are changing, and as I've long told you, one-on-one, but also publicly, I support from a high level your vision for more harmonization with our international counterparts. And I do think this the two rules today are a step in that direction, but certainly they are one step, and I look forward to the conversation today, but certainly in the weeks and months ahead as we look forward to further harmonizing our rules with our international counterparts. Thank you.
Thank you. Commissioner Stump.
In responding to the financial crisis 10 years ago, the G20 and Congress recognized that we regulate global markets, and we have to afford a fair amount of deference if we're going to do so effectively. I want to echo the comments that have been made and thank the chairman for his leadership in reminding us of that, not only here at this agency, but in international forums. I've had the benefit of participating in a few IOSCO events, and I want to say that the chairman is widely respected there in his efforts to advance these sorts of deferential and really practical application of the authorities and the mandates that we were given after the crisis. So thank you, Mr. Chairman. Specifically, the G20 leaders stated the clear responsibility that we have, and I quote, to take action at the national and the international level to raise standards together so that our national authorities implement global standards consistent in a way that ensures a level playing field and avoids fragmentation of the markets, protectionism, and regulatory arbitrage. I think we're all smart to be reminded of that being our mission from the onset. But more directly related to today's topics, I want to remind us all that Congress in the Dodd-Frank Act amended the Commodity Exchange Act such that the Commission may exempt, conditionally or unconditionally, a derivatives clearing organization from registration for clearing swaps if the Commission determines that the derivatives clearing organization is subject to comparable comprehensive supervision and regulation by the appropriate regulatory authorities in their home country jurisdiction. At the beginning of the year, many of you saw I penned an op-ed in the Financial Times and an effort to remind our international regulatory partners that we must recommit to this approach of ensuring that our alliances remain strong since the crisis. I'm committed to advancing a coordinated approach, and I believe the proposals we are putting out today are a first step in that process. There is, however, more work to be done in the way of the CFTC providing more deference and other jurisdictions, and vice versa. I hope that our international regulatory partners will also take the opportunity to reset and recognize that our shared interest of advancing derivatives clearing is best achieved by respecting the successes of those jurisdictions that have implemented the principles agreed to 10 years ago. Otherwise, it may unfortunately become challenging to advance the concepts of deference under consideration today to the next stage of the process. I do believe the deference to comparable regulatory regimes is essential, and historically such deference has been the guiding principle of the CFTC's approach to regulating cross-border derivatives. We cannot effectively supervise central counterparties in every corner of the world. We can, however, evaluate the regulatory requirements in the CCP's home country to determine if they are sufficiently commensurate to our own. We will never have the exact same rules around the globe. We should rather strive to minimize the frequency and impact of duplicative regulatory oversight, while also demanding high comparable standards, just as Congress intended. It is my opinion that had the CFTC previously established a more comprehensive structure for those comparably regulated CCPs in foreign jurisdictions that sought to offer swaps to U.S. customers, then CCPs wishing to seek the exemption Congress provided the authority for would have been able to do so under such a regime provided in the Dodd-Frank Act. Alternatively, those that wanted to register as DCOs would have done so voluntarily in response to a business rationale demanded by their clearing members and their customers. However, by not having previously established an exemption process, the CFTC left only one path for customer clearing in foreign DCOs, which resulted in compelling all foreign CCPs that wish to offer U.S. clients access to become registered with both their home country regulator and the CFTC. Unfortunately, as a result, relationships with our global regulatory counterparts have become strained, and there have been many unfortunate consequences, such that now we must provide new ground rules. So today, we are advancing an overdue conversation on applying international regulatory deference through the establishment of a test to identify non-U.S. CCPs that pose substantial risk to the U.S. financial system. To be clear, neither of the proposals we are considering today would be available to CCPs that pose such risk. I fear that this point may be lost or confused by the fact that we are presenting these as two separate rulemakings. While I would have preferred a single rulemaking to alleviate any confusion, I want to make clear that we are simply proposing two regulatory options, each of which only available to DCOs that do not pose substantial risks to the U.S. financial system. I encourage commenters to provide input on the proposals as if they were a single package, particularly where the request for comment in one proposal may be relevant or more applicable for consideration in the other proposal. These proposals are a step towards achieving the goals established in 2009, an effort I wholeheartedly support. However, I have concerns that the proposals may be a bit too rigid to pragmatically facilitate increased swap clearing by U.S. customers, as we are committed to do by the G20 and congressional directives. Under the alternative compliance proposal, non-U.S. DCOs can permit customer access only if an FCM is directly facilitating the clearing, while the exempt DCO proposal completely disallows the FCM from being involved in the customer clearing at all. While I recognize that the blunt nature of these bright line distinctions makes it easier to regulate, I worry that it may not be workable in practice. That said, I'm grateful to the staff who have worked diligently to advance this process, and they've spent considerable time with me and the folks who work with me. This is an issue of great importance to me, and I hope that once we receive comments, that we will have continued discussion to advance the ball. Thank you.
Thank you, Commissioner Stump, and also thank you for your sponsorship of the Global Markets Advisory Committee, where many of these issues discussed today will also be advanced in the months to come. Thank you. Commissioner Berkovitz.
Thank you, Mr. Chairman. One of the things I've appreciated about serving with you is your openness and the candid discussions we've had about the issues before the agency, and I look forward to today's meeting along those same lines that we've enjoyed in the past. We all here, this commission, I'm pleased to serve on. We all approach the issues trying to do what's in the best interest of the American people according to the mandate we've been given by Congress. We may have different views on how to accomplish that, but under your leadership, we've been all working in good faith to accomplish that mission as we see best. You've also built an excellent leadership team here, and they've been a pleasure to work with, both your staff in your front office, as well as the division directors. And today, I'd also like to recognize several of the division directors whose meeting this will be the last for them. Brian Bussey, Director of Division of Clearing Risk, Matt Culkin, Director of Swap Intermediary Oversight, and Eric Pan, Director of Office of International Affairs. I've worked with Brian, Matt, and Eric for many years now, since the first Dodd-Frank days in many cases, since I first came to the CFTC back in 2009, and it's been just a pleasure to work with you prior to coming to the agency, while I was away from the agency and you were at the agency, and then it's just been fantastic working with all of you here at the agency, and I thank you for your public service and wish you the best. One of the things, Mr. Chairman, I know you've been tireless about in your tenure here is supporting the staff and the resources for the agency, and I thank you for that effort as well, and that shows in the high quality of the staff that we have here throughout the agency and at the table before us today. So
I could just say the effort on resources has really been a bipartisan and consistent effort across, so I thank you as well for your support on that.
Thank you. I look forward to today's discussion on the rules before us.
Well, thank you. I'll just briefly review procedure for today's meeting. So for each of the two items on today's agenda, the staff will make presentations to the Commission. After each presentation, then there will be a motion to adopt the rule or item for consideration and ultimately adoption. I will then open the floor to questions from each of the commissioners. And after we've exhausted questions, we will then go to individual statements, if any, from commissioners. Following the close of discussion on each matter, the Commission expects to vote on the staff recommendation as presented, and Mr. Kirkpatrick will call the roll. After all final votes conducted in this public meeting, all final votes will be recorded votes. And the results of the votes approving the issuance of rulemaking documents will be included with those documents in the Federal Register. Now, at this point, it's appropriate for me to ask for unanimous consent to allow staff to make any technical corrections to the documents that may be voted on today prior to sending them to the Federal Register. May I hear oral approval? Without objection? Please say aye.
Aye.
Thank you. So ordered. Okay. At this time now, I would like to welcome the following staff for their presentations on the first proposal, the proposed rule on registration with alternative compliance for non-U.S. derivatives clearing organizations. That'd be Brian Bussey, Director of the Division of Clearing and Risk, Eileen Donovan, Deputy Director, Parisi Adabi, Associate Director, August Himmeltz, Special Counsel, and Abigail Knopf, Special Counsel. Welcome. Please begin.
Thank you, Mr. Chairman. The Division of Clearing and Risk recommends that the Commission approve two proposals today for publication in the Federal Register. First, as you point out, a notice of proposed rulemaking for registration with alternative compliance for non-U.S. derivatives clearing organizations. And second, a supplemental proposal regarding exemption from derivatives clearing organization registration, which we will discuss later this morning. Before turning it over to August, I'd like to thank Eileen Donovan and her very strong team in DCR, Parisa, Abigail, August, as well Eileen Chotner and Brian Baum, who are not at the table but were significant contributors to this process. As well, I'd like to thank Sai Srinivasan and his team in risk surveillance, Steve Greska, Bill Heitner, and Rick Torres. They provided a lot of the numerical, the data analysis that underpins these releases, and was very helpful to have that kind of data analysis. As well, Tom Smith is in the first row from DSIO, and his director, Matt Culkin, for all their hard work over many months on the recommendations. In addition, I'd like to thank our colleagues in GC, the Office of Chief Economist, and the Office of International Affairs for their work on the proposals. I'd also like to thank you, Mr. Chairman, for your leadership on non-U.S. DCO issues during your tenure, and your staff, as well as the commissioners and their staff. We have had only very positive interactions with all of you and your staff as you have considered the draft's recommendations of the staff, and the interactions have made the recommendations that much stronger in my view. With that, I will turn it over to August.
Thank you, Brian. Good morning, Mr. Chairman and Commissioners. As Brian mentioned, my name is August Imholtz. I'm an attorney in the Clearing Policy Branch of the Division of Clearing and Risk. And if you'll permit me a brief aside, Mr. Chairman, I think I speak for a lot of staffers, but I know I speak for this one. It's been a pleasure working for you and your team. But I'm here to discuss the notice of proposed rulemaking that is before the Commission, which is titled Registration with Alternative Compliance for Non-U.S. Derivatives Clearing Organizations, or DCOs. This proposed rulemaking would create an optional alternative compliance regime for non-U.S. DCOs that wish to clear swaps for U.S. persons and do not pose substantial risk to the U.S. financial system. Non-U.S. DCOs that pose substantial risk to the U.S. financial system would not be eligible for the alternative compliance regime. Before discussing the specifics of the proposal, it may be helpful to talk very briefly about the Commission's supervision of non-U.S. DCOs generally. Just to be clear, just to level set, when referring to non-U.S. DCOs in connection with this proposal, we are referring to clearing organizations that are organized outside of the United States and are registered as DCOs, or as the case may be, wish to become registered as DCOs. We're not referring to exempt DCOs, which will be addressed later in this meeting. When a non-U.S. DCO is registered with the Commission, it is subject to supervision, oversight, and regulation by at least two separate countries, and therefore at least two separate supervisory authorities, each of which is charged with implementing the supervisory regime of that nation. As the chairman has noted previously, the Commission has extensive experience supervising non-U.S. DCOs in these circumstances. Drawing on this experience, staff in DCR has prepared a proposal that reconsiders and recalibrates certain aspects of the Commission's supervision of non-U.S. DCOs. Let's turn to the substance of the proposal. As mentioned, the proposal consists of an alternative compliance regime for eligible non-U.S. DCOs. A good way to understand how the proposed alternative compliance regime would look is to start by considering how DCOs must currently comply with the Commodity Exchange Act and Commission regulations. The Commodity Exchange Act requires that in order to be registered and to maintain registration as a DCO must comply with each of the DCO core principles set forth in the Act and any requirements that the Commission may impose by rule or regulation. As you know, in 2011, the Commission adopted Part 39 of the Commission regulations to implement the DCO core principles, and it required all registered DCOs, both U.S. and non-U.S., to comply with those regulations. However, the Act also provides that, subject to any rule or regulation prescribed by the Commission, a DCO shall have reasonable discretion in establishing the manner by which the DCO complies with each core principle. Consistent with that, the proposal would permit non-U.S. DCOs to comply with the DCO core principles in the Commodity Exchange Act by complying with the legal requirements that exist in their home country. That is, with respect to compliance with the DCO core principles, eligible non-U.S. DCOs would comply with the legal requirements from their home country in lieu of complying with the corresponding Commission regulations in Part 39. Because DCOs subject to alternative compliance would be permitted to clear for U.S. customers through futures Commission merchants that are registered with the Commission, these DCOs would still be required to comply with the Commission's customer protection requirements. Specifically, this would include Section 4D of the Act, Parts 1 and 22 of the Commission regulations, and Regulation 3915 regarding treatment of funds. DCOs subject to alternative compliance would also be required to comply with the swap data reporting requirements under Part 45 of the Commission's regulations. In addition, they would also be subject to certain other reporting requirements, including daily, quarterly, and event-specific requirements that are similar to the existing requirements for DCOs. From the perspective of clearing members and customers, the difference between a DCO subject to alternative compliance and a traditionally registered DCO might not be apparent. Both would be fully registered, both would be permitted to offer swaps customers clearing through FCMs, and customer funds would receive the same U.S. bankruptcy protection at both. Now let's turn to discussion of eligibility for alternative compliance. Under the proposal, to be eligible for alternative compliance, a non-U.S. DCO must not pose substantial risk to the U.S. financial system. That means the Commission must determine that the clearing organization, and I'm going to quote the proposed rule text, does not pose substantial risk to the U.S. financial system. The proposal includes a two-part substantial risk test that focuses on the amount of initial margin required at the DCO. The first part of the test is whether required initial margin from U.S. clearing members at the DCO constitutes 20% or more of the required initial margin for U.S. clearing members at all registered and exempt DCOs. So put another way, what's the DCO's share of the global total required IM for U.S. clearing members? Is it more than 20%? The second part of the test is whether 20% or more of the required initial margin at the DCO is attributable to U.S. clearing members. So put another way, what percentage of the required IM at the DCO comes from U.S. clearing members? Is it more than 20%? If a DCO does not satisfy or does not exceed 20% for both parts of the test, then it does not pose a substantial risk to the U.S. financial system, and it would be eligible for alternative compliance. Where one or both of these metrics are close to 20%, however, the Commission may exercise discretion in determining whether the DCO poses substantial risk to the U.S. financial system. In these cases, in making its determination, the Commission may look to other factors that may reduce or mitigate the DCO's risk to the U.S. financial system, or factors that may provide a better indication of the DCO's risk to the U.S. financial system. In addition to satisfying the substantial risk test, to be eligible for alternative compliance, the Commission must determine that compliance with the clearing organization's home country regulatory regime would constitute compliance with the DCO core principles. The clearing organization must be in good regulatory standing in its home country, and a MOU or similar arrangement must be in effect between the Commission and the clearing organization's home regulator. Lastly, let's talk very briefly about how a non-U.S. DCO would seek registration under the alternative compliance regime. Under the proposal, among other things, an applicant would be required to demonstrate to the Commission the extent to which compliance with the applicable legal requirements in its home country would constitute compliance with the DCO core principles in the Act. To satisfy this requirement, the applicant would be required to provide a regulatory compliance chart that includes the citation and the text of each applicable legal requirement in its home country that corresponds with each DCO core principle, and an explanation of how the applicant satisfies those requirements. In conclusion, I hope this brief overview of the proposal has been helpful. We're happy to answer any questions you have about the proposal.
Is there any further of the presentation, or does that complete the presentation?
It completes the presentation on this proposal.
Thank you very much. We'll now go to questions, and we'll begin with Commissioner Quintens.
Thank you, Mr. Chairman. I guess I'll pose this to Brian, but anyone can answer. There was some discussion by the Chairman and Commissioner Berkovitz about the resources of this agency. I'm curious to know your thoughts on this proposal's, if it were to become a final rule, its impact on DCR staff resources in terms of considering potentially numerous new applications to become an alternative registered DCO, as well as the ongoing requirements after registration.
Thank you, Commissioner. We actually, even though we would expect the possibility of additional clearing organizations that are not currently within our regulatory ambit to come before us and require additional effort. Net, we actually think that this proposal would result in a reduction on resource demands at the DCR level. And let me explain that if I could. We have, as you all know, 16 DCOs that we regulate, currently registered DCOs. Of those 16, 6 are foreign DCOs. In the domestic context, of those 10, 2 of those DCOs are SIDCOs, the systemically important derivatives clearing organizations. Those DCOs absorb the lion's share of our boots on the ground up in DCR. The remaining resources that we have need to be allocated across both the domestic and international DCOs that we regulate. And of those remaining 8 DCOs, 7 of the domestic DCOs are DCOs where we are the only regulator in town. And that includes both LedgerX, the first cryptocurrency DCO, and just recently Eris joined them with their registration. And I can tell you, and I've told you in private, these are DCOs, although they're small in terms of volume, absorb a huge amount of resources. So I think the fundamental question, the fundamental approach that we can take if this proposal were to be finalized would be to step away from a number of our foreign DCOs, leaving it from a deferential perspective to the home country regulator or regulators, allowing us to focus our really important boots on the ground resources towards those domestic DCOs that we have sole authority for, as well as any foreign DCOs that that pose a substantial risk to the U.S. financial systems. Long answer to the question, definitely additional effort, because based on my industry conversations, I do expect new DCOs to come into the fold through the alternative process. But I think net, we're able to reduce, this reduces the demands and allows us to focus more smartly on where the risks are in our DCO landscape.
Thank you. I think that's a very important point. I think it highlights the importance itself of deference, not only from the perspective of our foreign counterparts, but also for our own efficient use of resources. Along those lines, there still is the ability to conduct examinations, but could you describe how you expect DCR to exercise that authority, specifically in regards to coordinating with foreign jurisdictions and our regulatory counterparts?
So currently, in terms of coordination, to start off, we have excellent relationships with our foreign regulatory colleagues. Most of our efforts currently are focused on the UK CCPs, ICE Clear Europe, as well as LCH. We coordinate very well with the Bank of England. We don't go in unannounced. We consult on scope of exam. We invite them along. We talk about our findings. We very much recognize that Bank of England is the primary supervisor. As I've said in many other public contexts, global CCP system does not work unless we all recognize a primary regulator for each CCP, us for our domestic global CCPs, other regulators in other countries for global CCPs in their jurisdiction. I would expect that same very cooperative spirit to extend to the DCOs with alternative compliance. I think the difference is the scope of, even though we retain the right to do a more general examination, I would expect that the scope of the examination would be much more narrow than currently the case. My expectation would be, to the extent that we were to do an exam, it would be focused on the customer funds protection rules that we propose to preserve in this proposal. In other words, we want to make sure, and it's a hallmark of our system, that in the event of a FCM bankruptcy, the customer funds protection regime works and works effectively and overnight to allow customers at the affected FCM to start trading the next day. That being said, the whole DCR exam program is risk-based. So in determining whether to examine an alternatively a DCO subject to alternative compliance, we would look at that as against other risk-based demands for our resources, both domestically and internationally, in making a determination. My own hunch, it will not be my determination since I'm retiring, my own hunch would be it would take a pretty significant amount of customer clearing before we would commit resources for a week of travel to a foreign country and all that's entailed with pulling together an examination. Again, weighing it against crypto custody issues at 2 DCOs, weighing it against the demands of our SIDCOs. But again, cooperative and risk-based will be our approach.
Great. Thank you so much. Thank you, Mr. Chairman.
Commissioner Benham.
Thank you. First off, dovetailing a little bit on the resource question, do we have any expectation about how many DCOs may avail themselves of this alternative mechanism? And is it potentially DCOs that are not within our purview right now, or do we expect some of these 6 foreign currently registered DCOs to potentially consider this as an alternative?
So of the 6, the 2 CCPs in the UK under the proposal would not be able to avail themselves of alternative compliance. LCH, as you all know, it represents, and this is a stunning figure, represents 50% of our cleared swaps market in the United States. That is a DCO. Even as good as the Bank of England is, we need to be a frontline regulator there, given the footprint that it has in the United States. For ICE Clear Europe, they would not be deemed to pose a substantial risk. However, for business reasons, ICE Clear Europe has for many years cleared futures contracts for a registered DCM in the United States. That's ICE Futures US. That is a statutory requirement that they must be registered. So even though for their swaps business they'd be technically eligible, because of their futures business, again, for business reasons, they would not be able to move to the alternative compliance regime. I've done a lot of industry outreach to DCOs, to regulators, to market participants, based on those many discussions over months and months, and the discussions that my colleague Eric Pan and Tracy Wingate have had as well internationally. We believe that there is a substantial amount of interest in Europe, among the CCPs in Europe, for the alternative compliance regime. They've been pretty clear that they're not interested in the exempt proposal, which is the next one on the agenda. Also, and I won't name names here, I've heard in a number of discussions there are CCP operators that are not currently in our regime at all. And they have expressed at least initial interest in exploring the possibility of coming in through alternative compliance. I'd guess a handful. The question that I have as this moves forward and moves past finalization, if the new commission finalizes it, is what happens to the Asian CCPs. We have 4 Asian CCPs, all of whom are exempt. They have been very interested in the exempt proposal. However, discussions more recently have suggested that at least some of them might actually want to be in the alternative compliance regime as opposed to the exempt DCO regime. To the extent I understand the thinking, it's a recognition from the market participants' discussions of the interest of having the FCM regime available and the protections that that brings, which is only available through the alternative compliance regime, not through the exempt DCO regime.
Okay, thank you. August, if you could elaborate a little bit on the 20%. I appreciate the very simple manner with which you described alternative. I think it's helpful for the commission, but more importantly for folks in the audience and listening on the webcast. But can you sort of help me understand the conversations, either intellectually or from a policy perspective, of how DCR came up with 20% as that threshold to measure substantial risk?
You know, that's a policy question that I am going to kick upstairs to my director.
Thank you, August. I think Commissioner Benham was trying to save the audience from listening to more of my answers.
No comment.
Nice try, Commissioner. To my mind, it's the contours are already coming out in the discussion. To my mind, the fundamental question that's being asked by the 2020 test is, when is it appropriate for us to be a frontline regulator of a foreign DCO that is that complies with our DCO core principles and has an effective foreign supervisor, and when is it appropriate to defer? That's ultimately, I think, the policy question that is being answered through this 2020 test. I think in thinking about this over many months, and we worked very closely with Bruce Tuckman and his team in Office of Chief Economist, and also with GC and OIA on this issue. A big part of it is the mission and resources that I've already talked about, and thinking about how we take the limited resources and use them most effectively. We also looked very closely at the data, and again, this goes back to Saeed and his team, the amazing data that they have at their fingerprints that they can produce analysis on with almost a touch of a button. It really is very stark, and if I can just quote some numbers to you, as I mentioned, LCH is a massive player in U.S. cleared swaps markets. It's technically 48%, almost 50% of the cleared swap market is being cleared in London at LCH. The next two largest players are domestic U.S. DCOs that are not subject to this proposal, CME and ICE Clear Credit. Together with LCH, they represent about 94% of the U.S. cleared swaps market. So the DCOs that we're talking about, ICE Clear Europe, LCH SA, Eurex in Germany, the Singapore SGX in Singapore, and the Canadian NGX, the ICE entity up in Canada, of the overall U.S. swaps cleared swaps market, they only represent in total about 6% of the cleared swaps market. So you basically have, from the perspective of the foreign market, foreign CCPs serving us, LCH is the elephant in the room. They represent by far the most amount of foreign clearing that's offered. The next largest foreign CCP that offers clearing services to the U.S. market only represents 4% of the overall cleared swaps market. So this is not a situation, we've all done line drawing exercises before. We know what's involved in line drawing exercises. This is one where the data is pretty stark on the ground, which I think provides us with some real flexibility in coming up with what the right answer is. Again, very clearly LCH. It's hard for me or my successor, I would assume, to tell this chairman or the next chairman we should walk away from LCH. When you jump from LCH down to another foreign clearinghouse that only represents 4% of our market, I think these policy issues, these resource issues really come to the fore. But it's a great question, and in fact, we ask this question very clearly in the release: have we got the substantial risk test right? And as I know you do, we welcome comments on this issue, whether we've calibrated it correctly. But again, in thinking about this issue, and Chairman and I have talked about this for more than a year. This is a domestic policy issue first and foremost. What is the right answer from a domestic perspective in terms of our approach to foreign CCPs in the universe that we live in of limited resources?
Thanks. That's very helpful. And like you said, I certainly look forward to the public comment on this particular issue. In the interest of time, I'm going to just throw out and truncate 3 questions with just the themes, and you can respond in kind, or we certainly can move on, but I do want to articulate other issues that I've sort of found with the proposal. Notwithstanding the 20% test, there is a bit of discretion provided to the commission to make a decision about whether or not we creep slightly above 20 or slightly below, and the other factors can be sort of the catch-all where the division and the commission can make a decision about whether or not someone is provides substantial risk. So a little bit of flavor to that would be helpful. And a little bit of a dovetail to that is, how are we going to reassess substantial risk on an ongoing basis? Certainly, this is not a moment in time that we can leave stagnant. We're going to have an ongoing conversation to make sure we are up to speed on changing markets and ultimately growing businesses if we have DCOs that are starting to clear more business. And finally, in August, you made a point with respect to a foreign jurisdiction's legal requirements as it compares to our core principles. And again, you articulated it very nicely and smoothly, but to me, it doesn't seem like it could be such an easy side-by-side of comparing, X's and O's with a foreign jurisdiction's legal requirements and our core principles. Perhaps I'm wrong, but to the extent that you all feel that it is actually not that difficult to, go to a foreign jurisdiction, lay out on a spreadsheet, however many legal requirements are required to match our core principles, do you see any challenge there to really make a sound decision as we sort of look towards comparability and that ability to provide alternative compliance? Thanks.
So I'm going to give you a break and let Eileen handle the first question.
Sure. So just to understand, you're asking about how much discretion the commission would have over 20%. The thinking behind that was to, rather than make this a very black and white test where if they're under the 20%, they're subject to full alternative compliance, and once they hit 20, they have to be fully under the commission's oversight. So the thinking there was, let's say you have a DCO who's around 25%, the commission would have the discretion to add some requirements then rather than having to make them. So it could be sort of ramped up as the volume grew rather than just having it be a sort of black and white test.
Very quickly on the reassessment, I first want to emphasize that looking at whether a DCO meets the test and the ongoing requirement to police that, we are proposing the CFTC's responsibility. Again, Saeed and his team have great data. It allows us to do it in a very efficient manner. One of the things, putting aside just the current shape of the foreign cleared markets, one of the things that I think you all know is this is a very sticky business. You don't see a lot of changes in where clearing occurs. It's much more gradual. In most cases, we might the counterexample might be coming up depending on how Brexit goes. But in normal times, you don't see huge shifts in clearing activity in this space. People have established relationships. They're established. Established arrangements and clearing arrangements both at the clearing member level and at the customer level to clear at a particular CCP. So we don't expect numbers to shift around dramatically. If we end up with a CCP that's close to the line, but we've said is not posing a substantial risk, I think we'd spend more resources on that than we would in the ordinary course. But the good news is, Commissioner Benham, again, we are a unique agency in having amazing data available at our fingertips every single day. It's refreshed every single day. So we have the flexibility, or my successor will have the flexibility, to design an oversight program that's pretty low maintenance, that would allow us to do as much as daily, although I don't think it's necessary. But we have that accordion flexibility given the data resources that are available to us. On the third question, did you want to handle that, Eileen, or August? Did you want to, on the analysis that's going to be required to determine whether the foreign regime is consistent with the core principles?
I'll take a crack at it, and if Eileen or Brian will jump in if I leave something out. What we're proposing is that the applicant submit a side-by-side of its home country regime against the DCO core principles. And I think it's important to make the distinction that the side-by-side is against the DCO core principles. It's not against Part 39 and its detailed granular requirements. So when we're talking about non-U.S. Regulatory regimes that have CCPs, we're looking at G20, G8 nations that have sophisticated economies and sophisticated regulatory regimes that implement in whole or in part the PFMIs, which are not, I shouldn't even say that in reference to this proposal, they're not part of this proposal, but we do think the side-by-side chart is a workable proposal, but of course we look forward to comments and thoughts from interested participants about whether it truly is workable.
Thanks, Mr. Chairman.
Thank you. For questions, Commissioner Stump.
I don't have any questions.
Thank you. Questions, Commissioner Berkovitz?
Thank you, Mr. Chairman, and I thank the staff of Brian and Eileen and August for that informative discussion in response to Commissioner Benham's questions. I have questions along some of the same lines and like to develop some of that further. And August, you just mentioned that the PFMIs are not part of this consideration on alternative compliance. And I think, at least I'm considering, and tell me if I'm wrong, this proposal in conjunction with the other proposal that we're going to be talking about in a few minutes, the Exempt DCO proposal. As I understand it, both proposals, essentially, Brian, I think you've articulated it pretty well. If you're above a certain level, call it activity or risk or whatever you want to call it, that's in the proposal measured by this 2020 test, the United States has a significant enough interest and there's significant enough activity or risk that we will assert full regulatory authority over the DCO. And clearinghouse like LCH clearly falls into that category. So if you're above a certain level, we're going to regulate you. You're going to be full registration. If you're below that level, there's a couple of options. If you don't possess the substantial risk, you can either go the exempt route or you can go the registration with alternative compliance route. And different DCOs may do it differently. If you go the registration with alternative compliance, the U.S. registered FCM is involved, you're a registered DCO, and you get full customer protections. If you go the exempt route, you're not a registered DCO. There's, as we're going to discuss later, there's not a registered FCM in the process. There's no customer protections. So is that essentially the correct framework? And you really should look at we really should be looking at these as a pair of proposals, and that provides the
Absolutely,
options.
yeah.
So the substantial risk test or whatever test is going to be the same, and that provides the non-U.S. DCO with an alternative. If they want the U.S. bankruptcy protection, then they go registration with alternative compliance. I guess I'm questioning, there's different standards for judging whether we're going to grant those applications for those non-U.S. DCOs that don't meet the substantial risk threshold. In the exempt DCO, it's going to require that the foreign regime is comparable and comprehensive. That's the statutory standard. And part of that is that they observe the principles of financial market infrastructure in the exempt proposal. Is that correct? Yes. But in this proposal, we're not requiring, as part of our examination, whether we're going to allow registration with alternative compliance, that they observe PFMIs. And I just wanted to say, why should we not be considering whether they're in compliance with the PFMIs as part of whether they're going to be in compliance with our regulations for registration? That's an alternative compliance.
Did you want to do it, or do you want me to? Okay. So your description is exactly right, and it's a very good question. The Commission has, through practice and now through this proposal, and not this proposal, I'm sorry, the exempt proposal, and its predecessor back in 2018, construed the comparable comprehensive language in the exemptive authority in Dodd-Frank to mean that we look to whether the foreign regulatory regime is consistent with the PFMIs. That is the interpretive approach that we took to that standard. There's other requirements, but that's the core analysis that we do for exempt now, for all of the exempt DCOs that we've done, and what we're proposing, what we proposed in 2018, and what we're reproposing now supplementally proposing or recommending supplemental proposal today. As you stated, the alternative compliance proposal before you right now requires, the analysis that it requires us to do is, does the foreign regime constitute does compliance with the foreign regime constitute compliance with the DCO core principles in the statute? So it's consistent with the PFMI versus constitute compliance with the core principles. A big part of the reason for that difference is because right now, when a foreign DCO or a domestic DCO comes in to register with us, the question that we ask is, are they complying with the DCO core principles? Our statute doesn't have us look to the PFMIs in the registration context. The question is, are they complying with the core principles? The statute also gives the DCOs reasonable discretion in how they comply, except to the extent that we have adopted specific rules, which we did back in 2011, as you know, the Part 39 rules for DCOs, which give a particularized approach to complying with certain of the core principles. So what we're doing here, in a sense, is allowing the foreign DCOs to go to pre-2010 approach to registration. So other than the specific rules that we've called out, with most notably the customer funds protection rules, the question is the question that the statute poses since 2000, which is what you're doing does it constitute compliance with the DCO core principles in the statute? I think the key policy issue, and this is another area where we bring it out in a question, and I look forward to the, or my colleagues will look forward to the answers, I know, is whether it's appropriate to focus solely on the DCO core principles in this analysis, or whether other parts of Part 39 should factor into our analysis as to whether a DCO can register from an alternative compliance perspective.
I appreciate that answer and that last part, and we had a discussion about that over the past few days. And I appreciate the inclusion that you've determined to include that question, are interested in the answer. And the question is, should we be looking not just at how the foreign regime compares to, or how they're going to comply with the core principles, but look to also our regulations, our Part 39, to determine compliance. And there's another question embedded in this, which is what's the basic difference between alternative compliance, which we're setting up here, where you were allowing, as I understand it, compliance with the core principles by complying with the home country regulations, and substitute compliance, which, if I were to describe substitute compliance, my description would be virtually identical to the description you've provided of alternative compliance. So now we're going to have an alternative compliance regime for this versus a substituted compliance regime we have elsewhere. Why do we need another regime with another description, and why isn't the basic substituted compliance regime adequate? But I think the answer goes that the substituted compliance regime would entail looking at the regulations, not just the core principles. But I think that just people should be aware really what's at stake here, what the difference between alternative and substituted is. I don't see that it's necessary, but I'm looking for or advisable, I'm looking for the comments on it.
Yeah, absolutely. And I think you've got that right, where at a 30,000 foot level, I think the analysis can be compared. The real difference, I think it could be said to be that we're not looking at the regulations. We are only looking at the core principles. We did a very granular substituted compliance analysis back in 2016, Eileen. In the context of the dialogue with the European Commission, that was very much a granular looking at the European rule book, looking at the Part 39 rule book, and determining whether a particular 39 regulation could be complied with by complying with an analogous European requirement. And we did that analysis, and we identified a number of provisions where compliance with the analog granular European rule would constitute compliance with the Part 39 rule. Under that approach, the Part 39 rule would still apply. It still applies. It's just satisfied through complying with the foreign regime. This is because we're focusing on core principles. It's a higher level of analysis, and again, consistent with the statutory framework, but still that policy issue that we've both now talked about.
Thank you. The other area I have also relates to follow-up on something Commissioner Benham asked about, and that's the 2020 test. It's described as substantial risk, but it's not absolute risk. It's really relative risk. It's a 20% of the initial margin. So it may be a certain threshold of margin, but that doesn't really say what the absolute. You could have a small, or could you not have a small percentage of risk of the global market in initial margin, and still have a significant risk to the U.S.?
I'm not sure that you could actually. I think part of the reason why we're focusing on initial margin is it's calibrated under these DCO or CCP margining systems to the risk of the product. So a relatively straight line, or a straight line product like an interest rate swap versus a product that's nonlinear, you'll have lower levels. So for the less risky products, you will have lower levels of margin for the same notional amount than you would for nonlinear products like CDS. So I think the initial, we're focusing on initial margin margin because we think it's a good proxy for a good proxy for analyzing risks to the system. In that environment, is it possible that a very small footprint CCP could pose a substantial risk to the U.S. financial system? I think it's worth thinking about the issue and getting comment on the issue. I question whether that's...
Is the risk being posed by the CCP or by the underlying activity? Are we considering that the CCP failure would present the substantial risk? Because that's what we're looking at.
That's right.
Here.
Yeah. Right, because we're in DCR. We're focused on the CCPs. Matt Culkin and Tom Smith and all of their team are focused on the intermediaries. Right, so to the extent that there's an issue with the intermediary, we have a regime that focuses on the intermediaries. We're really looking at the risk that the CCP would pose to the system. Obviously, it comes by way of the FCMs that are members of those CCPs.
Okay, I thank you. Thank you for that answer and the discussion.
Thank you. We'll now proceed to any final statements before calling the vote. Commissioner Quintens, do you have any statement to make? Oh, I'm sorry. Of course, Commissioner Stubb. Yes, please follow up with a question.
Sorry. I just had a follow-up question as a result of other questions that were asked. And Brian, you did a great job of, I think, describing how we're moving away from this line-by-line comparison of our regs to a foreign jurisdiction's regs. I am curious, in reading a recent consultation that's been put out by ESMA, it appears as though they are now suggesting that they may want to do a line-by-line, regulation-by-regulation comparison. And I'm just asking if that's an accurate depiction of what they are proposing to do. Thanks, Eric.
I guess I get to field this question. I think in general that is an accurate assessment based upon the consultation paper that ESMA's put out. It appears that they are looking for a very close requirement by requirement comparison from the DCOs.
Thank you.
Any other questions? Thank you. And I apologize. I meant to exhaust all questions before going to statements. Commissioner Quintens, you have a statement.
Yes, thank you, Mr. Chairman. This proposal, if finalized, would, in my opinion, reduce the degree to which CFTC registered foreign DCOs are subject to duplicative regulation by the CFTC and their home country regulator. The proposal recognizes that foreign regulators have a substantial interest and expertise in supervising DCOs located in their home jurisdictions. Deference to their oversight is appropriate when compliance with the home country regulatory regime would achieve compliance with DCO core principles, where the foreign DCO does not pose a substantial risk to the United States. In many ways, this proposal is consistent with and even an expansion of the CFTC's 2016 equivalence agreement with the European Commission, pursuant to which the CFTC granted substituted compliance to duly registered DCOs based in the European Union. I strongly support the proposal's transparent, fact-based, two-pronged procedure for determining when a foreign DCO poses substantial risk to the U.S. financial system, which I believe correctly assesses that DCOs focus on U.S. firms and its impact on the U.S. marketplace. In my view, today's proposal contrasts starkly with ESMA's recent proposal to determine the systemic importance of a foreign DCO to the European Union and thereby apply EMIR and ESMA oversight. Unlike today's CFTC proposal, ESMA has not proposed any quantitative thresholds for assessing systemic importance. Instead, ESMA proposed 14 indicators for determining systemic importance that would grant it considerable discretion and, in my view, raise serious questions about the judgment and consistency of those indicators' applications. I hope that through its consultative process, ESMA decides to revise those criteria and ultimately adopts a predictable, transparent, and appropriately calibrated threshold regime for such an important and extraterritorial regulatory determination. I welcome comments and suggestions from market participants and foreign jurisdictions about all aspects of the Commission's proposed alternative compliance regime for non-U.S. DCOs. It is also my hope that incoming Chairman Tarbert will prioritize finalizing a version of this proposal. And lastly, I look forward to discussing this proposal and advocating for its deference-based approach with our regulatory colleagues around the globe. Thank you very much, Mr. Chairman.
Thank you, Commissioner Quintens. Commissioner Bennett, please.
Thank you.
Statement.
Before I start my statement, I want to say that I think this is an appropriate application or appropriate situation where we're deferring to a foreign jurisdiction that's comparable or that we find alignment with in the interest of saving money, in the interest of being efficient and using our resources in the best possible manner. But I want to say that I think this should be a cautionary tale to this commission and future commissions, as we have struggled with our budget for a long time, that we have a very clear congressional mandate. We have very important, very large, and very systemically risky markets that we oversee. And I hope that, and I know this is not your intention, and I don't mean to say this or insinuate this at all, but I hope this is not the first step towards us having to manage our budget in a way that we have to start to find opportunities to give our jurisdiction or give our responsibilities away to other regulators. So that all said, I respectfully concur with the Commission's decision today to propose amendments to its regulations that would permit derivatives clearing organizations organized outside the United States that do not pose substantial risk to the U.S. financial system to register with the Commission and comply with the core principles applicable to DCOs set forth in the Commodity Exchange Act through compliance with their home country regulatory regime. The proposal contemplates a new paradigm for DCO registration intended to reduce the regulatory burden and ongoing compliance costs for non-U.S. clearing organizations seeking such registration, and permit the Commission to make more efficient use of its resources. While certain aspects of the proposed framework for evaluating the suitability of a particular non-U.S. clearing organization for registration with alternative compliance are concerning, I anticipate that the public will provide fulsome responses to the request for comments, especially with regard to those aspects of the proposal that introduce new ways to identify, measure, and evaluate risk to the U.S. financial system. The proposal sets forth a DCO registration framework that would differentiate between non-U.S. clearing organizations that are determined by the Commission to pose substantial risk to the U.S. financial system and those that do not. As noted, the new DCO registration framework would provide supervisory deference to a non-U.S. DCO's home country under certain conditions, most importantly where the non-U.S. DCO does not pose substantial risk to the U.S. financial system. The threshold determination as to what constitutes substantial risk, the clear identification of conditions that meet a minimum threshold of regulatory compliance, and the applicable standards for preserving customer protections will be paramount to successfully implementing this new framework. Under the proposal, non-U.S. DCOs that do not pose a substantial risk to the U.S. financial system and satisfy other enumerated conditions can meet the CFTC's DCO registration requirements through compliance with home country requirements. The Commission is proposing to define substantial risk to the U.S. financial system with respect to a non-U.S. DCO. And as I pointed out earlier, I'm concerned that the use of a 20% threshold may be an arbitrary bright line, especially given that the selection of initial margin as the measurement of a DCO's risk to the U.S. financial system is supported by rather conclusory evidence and absent significant analysis. The bright line test with its 2020 clarity is blurred by the Commission's proposal to retain discretion in determining whether the DCO poses substantial risk to the U.S. financial system, where both of the thresholds are close to 20%. The proposal suggests in making its determination, the Commission may, without seeking public comment or providing notice to the DCO, look at other factors that may reduce or mitigate the DCO's risk to the U.S. system or provide a better indication of the DCO's risk to the U.S. system. While I understand the need for flexibility, I'm concerned that the proposal's attempt to ensure the Commission has appropriate discretion may result in the abuse or the appearance thereof. Additionally, any subsequent Commission decision that considers other factors and deviates from the bright line 20% tests without the aforementioned public comment may be viewed as a new rulemaking in violation of the APA. I'm concerned that the tension regarding 20% being a bright line test and the Commission's unfettered discretion, which raises the question as to how much certainty the Commission is providing to DCOs regarding whether or not they pose substantial risk to the U.S. financial system. Additionally, pursuant to the Commission's authority under Section 4C, the Commission is proposing to exempt DCOs that are subject to alternative compliance from submitting rules pursuant to Section 5C of the CEA and Section 40.6 of the regulations, notwithstanding a few exceptions. Section 4C of the CEA provides that the Commission, by rule, regulation, or order, may exempt any transaction or class of transactions from any of the provisions of the CEA other than certain enumerated. In enacting Section 4C, Congress noted that the purpose of the provision is to give the Commission a means of providing certainty and stability to existing and emerging markets so that financial innovation and market development can proceed in an effective and competitive manner. While the proposed use of the Commission's authority under 4C in this instance seems prudent and is another illustration of our supervisory deference to the non-U.S. DCO's home country regulator, I must caution that such authority should be used judiciously. Although I have concerns regarding the substantial risk test in today's proposal and certainly look forward to the comments forthcoming, I will support the proposal because I believe it is a step in the right direction in identifying areas where the Commission can defer to non-U.S. DCO's home country regulators, where appropriate, in a manner that is consistent with our regulatory oversight responsibilities and what the statute dictates. I look forward to hearing from market participants and the public regarding the issues outlined above. And thank you again, Mr. Chairman.
Thank you. Commissioner Stump.
I again want to thank the staff for designing this proposal to more clearly spell out how we would provide regulatory oversight to those clearinghouses that do not pose substantial risk to the U.S. financial system and that may obtain an alternative compliance by demonstrating fulfillment of the core principles. I very much appreciate the tremendous effort and the amount of time you've all spent discussing these concepts with me, and I look forward to the public conversations and further conversations with the staff and the Commission regarding an issue that is of great concern to this Commission, but not addressed in this particular proposal: the increased strain on our registered FCMs. Under the alternative compliance proposal, any non-U.S. DCO seeking to apply the regime would be required to do so only through clearing members that are FCMs, and may not do so through an affiliate of the FCM in the home country that is already acting as a member of the DCO. This is a status quo, and frankly, it often makes very little economic sense for both the FCM and its affiliate to capitalize the clearinghouse simultaneously. In my opinion, consideration should be given to the efficiency of utilizing an affiliated entity, which would allow this to be a business decision between FCMs and their customers, rather than a regulatory impediment to sustaining FCMs that play a critical role in clearing derivatives markets. It is costly for FCMs to join clearinghouses, and it may be especially uneconomic if the FCM only has a few customers who wish to access a particular non-U.S. DCO. It may make more sense to structure the arrangement with the assistance of a non-U.S. affiliate already actively participating as a member of the DCO. To do otherwise, I'm afraid, limits U.S. customer choice and customer access to clearing, which seems at odds with the reform agenda of encouraging clearing, mandated or not. To be clear, two affiliate entities may each be subjected to risk mutualization obligations at the same CCP. And unfortunately, this proposal does not discuss how we might address this issue and a duplicative burden. As a Commission, I believe we are all concerned about the consolidation already experienced by these clearing service providers and the constraints on the availability of clearing services for market participants. I hope that we will be able to avoid policies that unnecessarily challenge the economics or otherwise impede operating an FCM. Otherwise, we may find that our mandate to increase swaps clearing is futile. Simply put, clearinghouses do not work without clearing members, and so we should seek to preserve both.
Thank you. And Commissioner Berkovitz.
Thank you, Mr. Chairman. I support the proposal before us today. Under the proposal, a non-U.S. DCO that does not pose substantial risk to the U.S. financial system would be permitted to elect to comply with certain CEA core principles through compliance with its home country regulatory regime. This alternative would permit U.S. persons to access foreign swap markets while, and this is the important part, continuing to benefit from customer protections under the U.S. Bankruptcy Code and CFTC regulations without introducing significant new risks into our financial system. The alternative compliance framework maintains key U.S. customer protection requirements and U.S. Bankruptcy Code treatment for U.S. customer funds. The proposal also requires the use of registered futures commission merchants. At the same time, the proposal recognizes the interests of home country regulators by relying on their oversight of other DCO activities. Although I support the proposal, I have several concerns. The staff, in their questions and answers and in description, ably described what I will call the 2020 criteria for assessing what is substantial risk to the U.S. financial system. I have concerns about adopting the 2020 criteria as a risk-based standard. The proposal has insufficient analysis as to the most appropriate criteria that would identify actual risk to the financial system. In fact, the proposal concedes that, quote, a test based solely on initial margin requirements may not fully capture the risk of a given DCO, unquote. This is important because, in my view, substantial risk to the U.S. financial system is difficult, if not impossible, to measure in a few simple metrics. Markets change over time in many different ways that cannot be anticipated. The activity-based thresholds in the Dodd-Frank Act for swaps markets and entity registrations were adopted largely due to the spectacular failure of the risk-based approach prior to the financial crisis. Significantly, the standard in Section 2I of the CEA for applying the swaps provisions to activities outside the U.S. is the activity must have a, quote, direct and significant connection with activities in or effect on commerce of the United States, unquote. This is really an activity-based standard, not a risk-based standard. So I'm concerned. I believe that the threshold for exemption from registration for non-U.S. DCOs should be an activity-based standard rather than a risk-based standard due to the difficulties in formulating an accurate risk-based standard. I look forward to reviewing comments on the 2020 criteria. I also am concerned that the proposal does not establish clear or consistent standards for the review of a non-U.S. DCO's application. The proposal would not require any determination that the home jurisdiction's requirements are comparable and comprehensive with respect to the CEA core principles and CEA and CFTC regulations for which alternative compliance is sought. It is not clear why we should have a different standard for alternative compliance than we have for substituted compliance, or why we should have a different standard for alternatively registered DCOs versus exempt DCOs. Finally, in this rulemaking, the Commission proposes to recognize the interests of other jurisdictions. I think this is appropriate in the interests of international comity. To the extent that non-U.S. jurisdictions adopt similar approaches that recognize the interests of the United States in the regulation of DCOs located in the UCS, in the U.S., the global marketplace as a whole will benefit. However, to the extent that another jurisdiction does not do so, then U.S. DCOs could be fully regulated by both the U.S. and other non-U.S. jurisdictions. This would put our DCOs at a competitive disadvantage to the non-U.S. DCOs, and that would be exacerbated by our regulatory treatment of non-U.S. DCOs. Prior to granting any applications for alternative compliance, the Commission should determine that the home jurisdiction adopts a comparable approach for regulating and exempting U.S. DCOs. After all, reciprocity is an important consideration in international comedy. I invite comment on whether reciprocity or a similar mechanism should be incorporated into the regulation itself. I again thank the Division of Clearing and Risk for their work on this proposal, and I appreciate their professional engagement with me and my office in helping fashioning a better proposal. And thank you very much again.
Thank you. I support this proposal. I've also produced a statement regarding this proposal, but in the interest of time, I won't read it now. It has been published on the website and will be submitted for the Federal Register purposes. With that, if commissioners are ready, we shall vote. Mr. Kirkpatrick, would you please call the roll?
The motion now before the Commission is on the approval of the proposed rule on registration with alternative compliance for non-U.S. derivatives clearing organizations. Commissioner Berkovitz.
Aye.
Commissioner Berkovitz votes aye. Commissioner Stump.
Aye.
Commissioner Stump votes aye. Commissioner Benham.
Aye.
Commissioner Benham votes aye. Commissioner Quintens.
Aye.
Commissioner Quintens votes aye. Chairman Giancarlo.
Aye.
Chairman Giancarlo votes aye. Mr. Chairman, on this matter, the ayes have 5, the noes have 0. The motion is approved.
Thank you. We will now move to the second proposal before the Commission, and that is the supplemental proposal on exemption from derivatives clearing organization registration. Mr. Bussey, will it be the same presentation team for this?
It will be, but this time it will be Abigail Knopf leading the presentation.
Welcome.
Good morning, Mr. Chairman, Commissioners Quintens, Benham, Stump, and Berkovitz. With regard to the Exempt DCO supplemental proposal, Section 5BH of the CEA permits the Commission to conditionally or unconditionally exempt a clearing organization from registration for the clearing of swaps if the Commission determines that the clearing organization is subject to comparable, comprehensive supervision and regulation by its home country regulator. To date, the Commission has exempted 4 non-U.S. clearing organizations from DCO registration to clear proprietary swap transactions for U.S. clearing members and future Commission merchants. In August 2018, the Commission proposed regulations to codify the policies and procedures that the Commission currently follows to grant an exemption from registration as a DCO. Today, staff recommends that the Commission approve a supplemental proposal which responds to public comments received on the 2018 proposal. Except as noted in this release, today's supplemental proposal does not replace or withdraw the 2018 proposal, which remains under active consideration for adoption as a final rule. Staff welcomes public comment on both proposals. Most significantly, today's supplemental rulemaking proposes to allow exempt DCOs to clear swaps for U.S. customers in addition to clearing proprietary swaps for U.S. clearing members and FCMs. However, as proposed today, U.S. customers would only be able to clear at an exempt DCO through a foreign intermediary and not through an FCM. Staff is not recommending at this time that the Commission propose to permit an FCM either directly or indirectly through a foreign member of the exempt DCO to clear U.S. customer positions at an exempt DCO. This is due to language in the Bankruptcy Code that suggests that the customer funds may not be protected in the event of an FCM's insolvency if the customer trades are cleared in an exempt DCO. Staff continues to examine this issue, including possible approaches to deal with that uncertainty and the possible risks to customers that may result from that uncertainty. The supplemental proposal requests public comment to assist in that regard. To facilitate an exempt DCO's ability to clear swaps for U.S. customers through a foreign intermediary, staff recommends that the Commission propose an exemption to allow persons located outside of the United States to accept funds from U.S. persons to margin swaps cleared in an exempt DCO without registering as an FCM. Among other things, a person seeking this exemption would need to be a clearing member of an exempt DCO, clear U.S. persons swap transactions directly in an exempt DCO, and not otherwise engage in FCM activities or voluntarily register as an FCM. In addition to the eligibility criteria for an exemption from DCO registration as proposed in the 2018 NPRM, staff recommends that the Commission propose to require that a non-U.S. DCO cannot pose substantial risk to the U.S. financial system as determined by the Commission. The Commission would apply the same substantial risk tests to exempt DCOs that August discussed earlier this morning. In addition to the conditions of exemption proposed in 2018, the supplemental proposal would require an exempt DCO that clears swaps for U.S. customers to have rules that require its clearing members to provide written notice and obtain an acknowledgment from U.S. persons prior to clearing. The notice would need to state that the clearing member is not a registered FCM, the exempt DCO is exempt from registration with the Commission, and the protections of the U.S. Bankruptcy Code do not apply to a U.S. person's funds. The notice would also need to explicitly compare the protections available to U.S. persons under U.S. law with those of the exempt DCO's home country regulatory regime. The supplemental proposal would amend the 2018 proposal's reporting requirements to better align an exempt DCO's daily and quarterly reporting requirements with the information necessary for the Commission to evaluate an exempt DCO's continued eligibility for an exemption and to assess the extent of U.S. business cleared by the exempt DCO. Finally, the supplemental proposal would permit the Commission to terminate an exemption upon its own initiative if the Commission determined that any of the terms or conditions of an order of exemption are not met. The supplemental proposal also sets forth the process by which the Commission may modify or terminate an exemption. At this time, we would be happy to answer any questions that you may have regarding the supplemental proposal. Thank you.
Thank you. Does that complete your presentation? Thank you. We'll now go to questions, beginning with Commissioner Quintez.
Thank you, Mr. Chairman. So there's a disclosure that's going to be provided to U.S. customers clearing through an exempt DCO clearing members, exempt DCOs clearing members that are not registered with the CFTC as FCMs.
Commissioner Quintez, may I interrupt you for a second?
Sure.
I'm sorry, I made a procedural mistake. At this point, I really need to begin our discussion with a motion to adopt the Division of Clearing Risk proposed rule. So if I could, can I have a motion on that, please?
So moved.
On this one here, this proposal.
So moved.
So is there a second? Okay, all in favor?
Aye.
Okay, thank you. Now the motion is properly before us. Please begin your questions.
Thank you. So I was just going to ask about the rationale behind that disclosure.
Yes, the purpose is just to make sure, because typically U.S. customers would clear through FCMs and be expecting U.S. bankruptcy protection. So the idea behind this was just so that they're clear that U.S. bankruptcy law would not apply, and to compare the local bankruptcy law to U.S. law so they understand the differences.
So they would be fully aware of the differences and can make their own informed choice and their own business decision as to which regime they'd like.
Yes, that's right.
Okay. I had a question on the 2020 test and how it's going to be monitored or evaluated or implemented. Brian, you had said that the DCR would be doing that, would be performing that function. Can you give us a sense as to how you expect them, the division, to do that over time? Will it be something they look at every day? You think they'll be taking some type of average over a period of time? Obviously, there's some discretion in terms of crossing, a 2020 line. But give us a sense as to, how you think the division in the future will be looking at this and monitoring it.
Sure. We've had some discussions internally. We have a great team in risk surveillance and great access to data. It's one of the, I can't take credit for it, visionaries 10 years before me put in place an amazing data system that the new deputy director is only building on and making better. That gives us a lot of ability to look at data in a way that not many other regulators can on a daily basis or less frequently. 2 points. One, the current contours of the role that foreign swaps clearinghouses play in the U.S. market. There's one large player, as I mentioned before, and then a lot of very small players. So we don't have a lot of We don't have a lot of folks that are close to the line that we're proposing, and the line would have to be substantially lower for people to be in play. In addition, as I mentioned, the business is all of you know, and a lot of folks in the room know, it's pretty sticky business. You don't see major moves in level of business. I think those are factors that will be taken into account by Eileen and Saeed and the new director, among others, in determining how to approach this issue. But again, I think the key is the new director has an accordion. We can do it as frequently as necessary, including daily, or less frequently as warranted. And then the other key feature, and you've pointed this out, but I just want to emphasize it for the audience, this is not a burden that the staff is proposing to put on industry because of our data sources, our data access. We are putting it on ourselves in DCR to monitor the cleared markets and make determinations as well. The proposal builds in a substantial lead time. So if an entity is registered under alternative compliance, they get close or go over, say in a Brexit situation, for example, it would not be the case that they would have to all of a sudden come into full compliance the next day. There is a runway that's part of the proposal that would give them sufficient time to come into compliance with the full registration regime.
Okay, thank you. And I just had another point of clarification quickly on something Commissioner Berkovitz brought up before. The second part of the 20% test on total margin held across the global markets, that's 20% of global U.S. margin. Is that correct, or is it?
That's right. It's looking at the share of the U.S. cleared market, both looking at domestic clearinghouses that are servicing the U.S. cleared market, as well as foreign clearinghouses that are servicing that market. So that is the denominator. The denominator is all U.S. Facing cleared business, regardless of the location of the clearinghouse. The numerator in doing the test is at a foreign DCO, how much of the overall U.S. cleared swaps market do they have, and that's the numerator and denominator that gets you to a number that is either above or below 20% or close.
Okay, so not global initial margin across all countries and entities, just U.S.
This is focused solely on the U.S. That's actually another distinction between us and the ESMA consultation. I believe that they're looking at global market share as opposed to U.S. Looking at share of the European market.
Okay. And finally, Brian, just for you, you had significant experience at the SEC. Before coming here, and I've been the beneficiary of that expertise, especially most recently with the discussions we've had and the advice you've given and the work you did on our negotiations with them on their capital rule, and I'm very appreciative of that, and
Thank you very much.
Very grateful for it. But from your experience there, could you give us a sense as to their approach for foreign custody issues, and whether or not there are any similarities between that approach and what this proposal puts forward?
Sure, it's a great question. In fact, I started back in the SEC in late '98. It was around that time, '98 through about '03, that the Commission spent a lot of time thinking about foreign custody issues in the context of investment advisors and retail mutual funds. the retail mutual fund modification to a longstanding approach, I think, was adopted around 2000. In the investment advisor space, there was a proposal in 2002. It was finalized in 2003. Thank you for giving me a heads up on this question. I spent a minute last night refreshing my recollection on the proposal, which I worked on when I was in the chairman's office at the SEC. I call out, I think, the core of what your question raises, Commissioner, a statement in the 2002 Investment Advisor Custody Proposing Release. They said, we recognize that advisory clients often invest in securities traded on foreign exchanges, and their advisors must, as a practical matter, maintain securities with financial institutions in foreign countries where the securities are traded. In other words, if you're going to be an advisor, if you're going to be a retail mutual fund that's focused on foreign securities, there's just the Commission recognized back long ago that as a practical matter, there needs to be a way to use foreign custodians. They grappled with that issue for years and years. In the investment advisor context outside of mutual funds advised by investment advisors, they took a pretty liberal, classically liberal approach to the issue, and essentially they allow an investment advisor to place a customer's funds at any foreign financial institution as long as the assets are segregated from proprietary assets. But what they did was they put the burden on the investment advisor based on their fiduciary duties to make sure that they had a reasonable basis for believing that the foreign institution will provide a level of safety for client assets similar to that which would be provided by a domestic qualified custodian. So the approach is very classically liberal, but putting the burden on the investment advisor to do the analysis before placing their client assets at a foreign custodian. This approach dovetails very well into that. So to the extent that there's an investment advisor that would rely on this if it were adopted, our proposal would give that investment advisor the information on the bankruptcy regime that would assist in them satisfying their fiduciary obligations that have been placed on them by the SEC. In the investment company context, because it's potential retail exposure, they have a much more specific regime that needs to be followed. But again, they put the burden on the mutual fund to go through analysis before deciding to place assets as a foreign custodian. But they do not do a bright line rule that says you cannot use a foreign custodian. Very similarly, and as we all know, investment companies, mutual funds are ECPs, eligible contract participants. They would be eligible to use this proposed exempt DCO proposal. The disclosure would not be the end of the story. The mutual fund board would be under substantial obligations under SEC rules to make sure that the custodial solution that they're using for their client assets at the clearing member are adequately protected. So I can't help but give long answers, but it's a really good question, and I think, in a sense, SEC has been the leader on this. I mean, I don't often say that, but they really have been a leader going back many, many years, recognizing just fundamentally, if you're gonna give people the economic ability, or you want them to have the economic ability to participate in foreign markets, you have to recognize that you have to allow them to use foreign custodial solutions.
Can I just make sure I understood the answer to your question? Sure. So I learned a lot, but I just want to make sure that what you're saying is the proposal before us would be well aligned with the SEC's current practice with regard to custodians.
Right.
Yes or no?
Actually, yes, and would support it. I think you should go to the Democratic debate format. Just do yeses or nos across at least for me.
Thanks, Brian. That was a very important point. Thank you for making it and taking your time with it. I appreciate it. And thank you and the team for such great work on this and the prior rule and for working with my staff so well. And Brian, thank you for your distinguished service to the government and to the markets and to the American people. I've really enjoyed working with you. And let me also take this time to just thank Matt Culkin and Eric Pan for their work, and also Erica Richardson, who's not on the front line here. She's on her own front line in the back there. Thank you all for your work. It's been an honor to work with you. Thank you.
Commissioner Benham, questions?
Yeah, we'll just follow up on that last question while we're on it. The proposal cites 2E as our sort of prohibition on offering foreign swaps to customers other than ECPs. So in this situation, we have foreign intermediaries. What would, and Brian, I think you got to this point in this last, in Commissioner Quintenz's last question. Give me some comfort and give me some idea of how I can be assured that retail customers are not going to be able to be offered access by these foreign intermediaries.
This prohibition that you mention is very much at the forefront of the mind of industry based on discussions that I've had going back to the adoption of Dodd-Frank in 2010. My understanding is the industry is very careful because it makes it unlawful. If I do a swap, if I'm a dealer and I do a swap with a retail person, other than on a CFTC regulated designated contract market, the transaction is unlawful, right? So I think there are, my sense from lots of discussions, there are systems in place to make sure that folks that are doing swaps in the market, and actually I know as well it's not just a domestic issue because the foreign swaps market participants are very aware of this prohibition and the analog prohibition in the SEC's portion of Dodd-Frank, very aware of this issue and work to make sure that they are not doing over-the-counter swaps or non-DCM swaps on the SEC non-national securities exchange swaps with retail customers.
Okay. Obviously, it's a significant issue, and with respect to the foreign intermediaries, understanding our laws, and I completely appreciate the fact that domestic intermediaries will appreciate the requirement of ECPs. It's sort of a hallmark of our statute, but within this proposal, we'll have foreign intermediaries being the intermediary and their appreciation and understanding of our laws. And you mentioned mutual funds, right? That's a perfect example of an entity that has passed through retail investors, but they, as ECPs, would have access to this market. So a concern of mine, but making sure that we're all on the same page, and it seems like you understand those risks and are thinking about them. Regarding bankruptcy, the supplement suggests that in order to mitigate the bankruptcy concerns, which Abigail noted, sort of two prongs to make sure the DCO is in good standing, and second, require, again, a foreign intermediary to write a written notice and obtain an acknowledgement from a U.S. person in advance of engaging in any clearing on their behalf. Can you talk about this written notice? And, it seems like we're going to have to get lawyers involved, and there's going to have to be some really credible acknowledgments and disclosures about who's participating and making sure that this is all okay. And again, given the fact that we're now in a foreign jurisdiction, I want to make sure that these things are done properly and if they're adequate.
Sure. I mean, we have some experience now with foreign DCOs that offer customer clearing through FCMs. They have to provide ring fencing memos that do an analysis of their local bankruptcy, whether U.S. bankruptcy law would be honored under local law. So I think our expectation is that the Exempt DCO itself would do the analysis and provide it for their members, and we would have an opportunity to review the disclosure to make sure it adequately addresses our concerns.
Thank you. And finally, 4C and the use of the authority. I pulled up. I think 4C was drafted in statute in the early 90s, and there was a little excerpt, and I think one of the first uses of our 4C authority in a Federal Register notice, and there's a quote about congressional intent saying, the Commission is to consider such regulatory concerns within the purview of 4C, market surveillance, financial integrity of participants, protection of customers, and trade practice enforcement. So focusing on that protection of customers, given the sort of ambiguous nature of the bankruptcy protections for U.S. customers and the questions that we're posing to the public to give us some level of certainty or give us a different point of view, is this the appropriate use of our 4C authority, given what Congress intended and given the uncertainty that we potentially have about bankruptcy protections? That's the wrong way to frame the question. Have you thought about this and whether or not our use of 4C is appropriate in this instance, given the bankruptcy concerns?
We've worked very closely with our in-house bankruptcy expert, Bob Wasserman, as well as General Counsel's office on these issues, but particularly the General Counsel's office on the use of 4C authority. We obviously want to make sure that we're making a recommendation that's consistent with the General Counsel's view of the Commission's authority. We do, that is a prong in 4C. We think the disclosure approach. So we're taking, as you all know, a disclosure approach to dealing with the foreign bankruptcy issue. Written notice and acknowledgement back from the customer as an approach. We think, given the nature of the participants and given the approach that it is a consistent use of 4C authority. Dan, if you have. I've really enjoyed working with the General Counsel's office here at the CFTC, and it's particularly nice to have him here on 4C questions.
This wasn't my intention, Dan, but it's fine.
I'm always happy to answer a question. We reviewed the rule. We think it's within the Commission's authority under 4C. Of course, it is a proposal, so naturally we will be looking at any comments with respect to any assessment that anyone wants to provide with respect to the 4C and this particular use of Section 4C, and we'd be happy to review those comments.
Thank you. Commissioner Stump.
I just have one question, and it's kind of a follow-up to a lot of things that have been discussed, but with a slightly different angle. For the purpose of enabling futures customers, who, by the way, do not have to be ECPs, efficient access to clearinghouses who utilizing foreign boards of trade. Under Part 30.7, we permit FCMs to deposit margin with depositories of non-U.S. clearing members of such non-U.S. clearing organizations. Is that correct?
Absolutely, and I would emphasize that this is it's not just retail in the foreign futures context. It's also it's not just eligible contract participants. It's also retail can do this in the foreign futures context.
Okay. So we allow for that for futures, that they would be able to utilize their FCM to deposit customer funds in a foreign depository of a non-U.S. clearing member at a non-U.S. registered clearinghouse.
That's correct.
So now I'm going in a little different direction. Under this proposal, which disallows the involvement of an FCM, we're proposing new disclosures, which I think is a great idea, to the cleared swaps customers under 39.6B2 in the proposal. What is the common practice employed by FCMs for disclosures explaining the treatment of customer funds outside the U.S. who clear foreign futures for U.S. clients at non-U.S. clearing through non-U.S. clearing members?
Our good colleague Tom Smith from DSIO will field that.
Thanks, Tom.
Oh, you're welcome.
That's like the hot seat today, that last share.
Exactly. Hopefully I can answer your question. So yes, that's correct. If a FCM has customers, whether they're U.S. customers or foreign customers, but they're going to trade foreign futures contracts, there's a provision on our regulations that requires that FCM to provide a disclosure document to that customer, depending again whether they're an ECP or a non-ECP. But if it's a retail customer, they get that disclosure. And my understanding is if it's an ECP customer, they're not obligated to. But general practice is that as the part of the account opening process, they provide them with that same type of disclosure, and it mandates certain language. But it does discuss that with respect to foreign futures, you are trading outside of the United States. It's not subject to the exclusive jurisdiction of the CFTC or the U.S. Bankruptcy Code. You have to take your own steps to understand what the rights are and protections are in that foreign jurisdiction.
Thank you. It's very helpful.
Commissioner Berkovitz, questions?
Thank you. Brian, or appropriate person, we've been talking about the bankruptcy code sort of in the abstract. Could you explain the benefits of why we care, the benefits of the bankruptcy code for derivative markets, and how and whether the bankruptcy code can help reduce systemic risks presented in those derivative markets? Could you first describe the protections, and then we'll get to the risk issue.
Right. So a customer, frankly, not just U.S. Customer accessing a clearinghouse through an FCM for swaps has substantial bankruptcy protections that have been proven out over time on many occasions. We have very clear bankruptcy code language as well as analog authority under the CEA, which we've exercised under Part 190 to deal with a host of bankruptcy issues. As a result of this, with a high degree of assurance, a customer who ends up in the unfortunate situation of having an FCM that it uses go into bankruptcy, there's a high degree of assurance that that customer will be able to have its positions ported to another FCM. It's usually, I think, thank God it hasn't happened under my watch or Chairman Giancarlo's watch, but my understanding is Bob Wasserman has been in court a number of times in his career at 2 a.m, making sure that positions get transferred from the failing FCM to a new FCM. It's seamless. Why does that matter from a risk perspective, going to your question? In a situation where you have a failing FCM, you might likely have roiled markets. The last thing that you might want is to have a large number of positions that need to be closed out because you can't do the transfer to a new FCM, and that closeout and reopening in bad markets might roil those markets. So the general approach that the CFTC has taken and the staff has taken is to make basically pretty low tolerance for risk in the bankruptcy area. We want to make sure that the bankruptcy code will work when it's needed. That's at 2 a.m. On the day of a failure. Or the overnight of the failure. I look at numbers, and I'll use the example of LCH, where U.S. customers must use FCMs to access LCH. Non-U.S. customers are not obligated to use FCMs. They have the European solution, which is called the swaps clearing member. The data, and I just got very recent data, again from LCH, it's fair to say the overwhelming choice of non-U.S. customers is to use the FCM, not other solutions that are available. I think that is a testament to this commission's and prior commissions' tending of the bankruptcy regime for FCMs and the success that we've had in multiple bankruptcies over many years with good outcomes.
So not only does it protect individual customers who voice their support of this, or they're putting their money with the U.S. FCMs to get those protections, but there's systemic benefits to other market participants. It prevents a cascading of sales and moving of positions in the event of a bankruptcy in a single firm.
That's right.
Can the failure of a single firm, it doesn't necessarily have to be as big as Lehman Brothers, but it could be a hedge fund such as Long-Term Capital, can the failure of a single firm have systemic importance?
Yeah, depending on the firm, I think we have examples of that.
We have examples. So we permit this proposal parties to trade at these persons, ECPs, to trade at these exempt DCOs with a notice. They'd be given a notice that no bankruptcy protection applies. Is the theory somewhat, these are sophisticated counterparties, they can accept the risks if they choose to?
I think that's right. And again, going back to Commissioner Quintenz's question, it's an approach that our fellow regulators have taken as well to this situation. I would just, because I can't help myself, just want to add one point. I've thought about this many times. I've used the example, maybe even with you. Basically, we want to, we as the staff in the proposal want to put a sophisticated U.S. person who doesn't have access, for example, to the Japanese market, JSCC, to make the choice based on full disclosure, make the choice from an economic perspective, weighing the protections that they get under the Japanese bankruptcy code, weighing the choice whether they want to access the Japanese market and obtain the same protections that Japanese hedge funds and Japanese grandmothers get every day in their regime, or do we want to say we don't want to allow them to make that decision and not give them access to that cleared market in Japan or in another jurisdiction where there's a vibrant swaps cleared market.
My concern with permitting them to do that is that the choice they would be making, it's not just their own, the bankruptcy code's protections for themselves. They'd be saying, well, I'll take this risk, but being unprotected leaves others at risk as well. So the protections are not just for that customer.
Right.
They're for the entire systemic risks caused by the potential failure of the non-FCM intermediary at this exempt DCO. It could have cascading effects in the U.S. market. It's not just their waiver. Philosophically, I also want to go back a few years, and it's not that long ago. We built, this country and the Congress built an entire deregulatory system on that philosophy. The CFMA, the Commodities Futures Modernization Act of 2000, was largely premised on the philosophy that the market participants, these were swaps markets, derivatives markets, sophisticated market participants are much better assessors of risk and can manage risk much better than the government can. And the philosophy then was get the government out of the way because it's only impeding the market and impeding informed choice by market participants, that the large banks and the large institutions would act in their own self-interest and not take unduly risky behavior. That was an absolute spectacular failure. That whole philosophy led to the financial crisis. And let me quote the architect of that philosophy, the man who firmly believed it and who put it into place and supported it for year after year after year, and his testimony in October of 2008 before Chairman Waxman in the House of Representatives, where Alan Greenspan, in his own inimical way, admitted that philosophy is a total failure. You can't rely, when systemic risk is involved, you can't rely on market participants in their own self-interest to protect the system. And Alan Greenspan, this is a great quote from Alan Greenspan, Those of us who have looked to the self-interest of lending institutions to protect shareholders' equity, myself included, are in a state of shocked disbelief at the financial crisis. It didn't work. It was a failure. I don't think we can go back and say, well, these are sophisticated market participants. They know the risks. Let them assume the risks without bankruptcy protection. The bankruptcy code applies to our market participants, not just to protect them, but to protect the entire U.S. financial system from the cascading effects that we've seen. We've seen it with Lehman Brothers. We've seen it with long-term capital. We're going to have to bail out another one of the institutions in a foreign market that goes unprotected someday.
Right.
So I'm really, really concerned about that. I have a little more say in my statement, and I thank you. I fundamentally disagree, but I thank you for your work on this.
I'm going to miss working with you. I'm sorry that you came back so late in my tenure because we had great times early on. I still remember the trip to New York. I absolutely hear what you're saying, and we've had many good discussions on this topic. I'd respectfully distinguish I worked on CFMA on Title III. I'm very aware of the philosophy that went into it. I would respectfully say that what was done in Title III of the CFMA back in 2000 is not what we're doing here, right? This is much more narrow, and I'd also say, I'm not trying to argue, again, hearkening back to the example of SEC mutual funds, right? Today, 30-40% of my portfolio is in foreign mutual funds, right, that are using foreign custody solutions under essentially the same philosophy that animates this approach. Right, it's we have and not just mutual funds, investment advisors representing other non-mutual fund clients, very clearly consistent with this approach. Right, this has been going on for 20 years. Survived the financial crisis. Right. So I absolutely hear what you're saying. We have to learn from, we must learn from mistakes, and it appears that we have with Dodd-Frank Act. We've learned mistakes of the CFMA, but this I think is I hear what you're saying. I think it might be different in kind.
I appreciate that. Thank you. Well, I hope we'll have ethics codes permitting, whatever you're.
Couple of years.
Further discussions down the road.
Well, thank you. Are there any further questions? Okay, then we'll proceed to statements. Commissioner Quintens.
Thank you, Mr. Chairman. In the interest of time, I'll just have my statement published on the website and insert in the record, but I'm very pleased to support this proposal. Thank you for your work.
Commissioner Benham.
Thanks, Mr. Chairman. This won't feel brief, but I'll shorten it. But I will submit also my statement for the record. And before I begin, I want to thank all of the panelists, Parisa, August, Abigail, Eileen, and of course, Brian. Congratulations to you. Thanks for your service. And also to Eric and Matt as well for your service. It's been great to work with all of you. American journalist Michael Spector has said that it doesn't seem to matter how often vaccines are proved safe or supplements are shown to offer nothing of value. When people don't like facts, they ignore them. That quote appeared in an opinion piece from 2010 titled "Fear of Science Will Kill Us." In that piece, Spector was commenting on the threat to scientific progress posed by the growing phenomena of denialism. Regarding that threat, Spector noted, "Denialists replaced open-minded skepticism of science with the inflexible certainty of ideological commitment." While we're not here today to discuss science or debate the value of dietary supplements, I couldn't help but make the connection between my concerns with the supplemental notice of proposed rulemaking we are voting on today, which addresses the granting of exemptions from DCO's registration to non-U.S. clearing organizations and further permitting such exempt DCOs to clear swaps for U.S. customers through intermediaries that would be wholly outside the Commission's direct regulation and oversight as a continuation of the Commission's trend towards pursuing policy shifts driven by ideological commitment as opposed to serious and careful study, sound market and legal analysis, and fulsome consideration and assessment of alternatives. I will not be voting for the supplemental proposal today. While I supported the Commission's 2018 proposal to codify its current policies and procedures for granting exemptions from DCO registration as a positive step towards increased cross-border cooperation and deference to our regulatory foreign counterparts, I cannot support it in its supplemental form. The supplemental proposal is not the product of internal consensus, and its brief history and questionable timeline signal a lack of appropriate scrutiny and evaluation of the potential consequences of taking these first steps towards diverging from the customer protection model set forth in the Commodity Exchange Act. The supplemental proposal was drafted ad hoc in an attempt to capture a conception of how U.S. swaps customers may fare outside the protections offered through operation of the U.S. Bankruptcy Code. The critical issues raised by the supplemental should be considered in the context of a more fulsome and informed discussion. I support the Commission's endeavor to explore ways to adapt and, if appropriate, seek to alter the current intermediary structure established under the CEA and Commission regulations in order to better accommodate both U.S. customer demand for increased access to clearing in foreign jurisdictions and evolving global swaps market structures. However, I cannot support the Commission's proposed use of its public interest exemptive authority to create a regulatory easement as a shortcut to legal certainty in furtherance of such efforts. If the Commission believes it's appropriate at this time to provide U.S. customers with greater access to non-U.S. swaps markets, then we can and should engage in a more careful analysis of options, assessments of alternatives, and evaluation of consequences. Today's supplemental proposal, in its timing, in its limitations, and in its uncertainty, is at best false progress and at worst the false promise of benefits that will never be realized. Separately, the supplemental proposal utilizes its request for comments primarily to explore why this proposal represents the regulatory route that will cause the least amount of harm by soliciting the public for their best arguments as to the operation of the U.S. Bankruptcy Code, and to solicit feedback on eligibility elements and several conditions of the exemptions for DCOs. However, it also introduces and requests comment on alternatives to the Commission's longstanding policy of allowing U.S. customers' swap positions to be cleared only through registered FCMs at registered DCOs. While this is an entirely inappropriate issue to raise in the context of a proposed rulemaking, the effectiveness of any comments received will be largely lost in this supplement, since the line of questioning fails to accentuate or itself propose a rule from which any final Commission action could be taken as a logical outgrowth. A line of questioning that seeks to introduce potentially new policy considerations for future consideration by a Commission in the midst of changing leadership is ill-fated, detracts commenters from the critical issues at hand, and undermines the integrity of the 2018 proposal and the supplemental proposal. My concerns with the supplemental relate generally to the Commission's decision to permit DCOs that are exempt from registration to clear swaps for U.S. customers, in spite of ongoing uncertainty regarding the extent to which U.S. customers' funds would be protected under the U.S. Bankruptcy Code, by providing an exemption for foreign intermediaries whose activities and handling of U.S. customer funds would ensure that they remain entirely outside of CFTC oversight in the application of the Bankruptcy Code. While the Commission's decision to put a premium on legal certainty is laudable, it's not clear to me that the Commission ought to do so if it undermines key components of the CEA's customer protection regime and misaligns the Commission's use of its public interest exemptive authority with the purposes of the Act. It appears that in attempting to deliver on the concept of permitting exempt DCOs to clear swaps for FCM customers, the Commission found itself boxed in by uncertainty. The only way out is to remove any and all doubt that a U.S. customer who seeks to clear swaps on an exempt DCO will have to do so through a foreign intermediary not subject to CFTC regulation or oversight and outside the protections of the U.S. Bankruptcy Code. It's clear that the supplemental proposal and the proposal to adopt an alternative compliance regime were, at least at one point in time, intended to be issued as a single proposal to address the CFTC's approach to non-U.S. clearing organizations via two options. Given ideological differences of opinion, the single proposal was bifurcated. In doing so, I believe we may at best have muddled the record and left some typos, and at worst created unnecessary costs and burdens for commenters who will most likely be affected by and wish to comment on both the supplemental proposal and the proposal for an alternative compliance regime. Thank you.
Commissioner Stump.
But before I give my statement, I just wanted to provide a little bit of context. The CFTC implemented the clearing elements of the G20 principles long before other jurisdictions. And in that context, I think we determined that any non-U.S. CCP wishing to offer cleared swap products to U.S. customers was going to have to become a fully registered DCO with the CFTC. But today things are different, and we can assess finally, based upon fellow regulatory bodies around the globe having also implemented their own complementary reforms, thus aligning many of the regulatory principles just as the G20 originally envisioned. Notably, in authorizing the CFTC to implement these G20 principles, Congress recognized that consistency, not duplication, is the goal, and therefore provided authority in the Dodd-Frank Act to specifically exempt, either conditionally or unconditionally, a third country CCP from registration with the CFTC, if we determine that the entity is subject to comparable, comprehensive supervision and regulation in its home country. Certainly, individual CCPs around the world should be able to seek registration with the CFTC to clear swaps for U.S. customers if they determine that it's appropriate based upon their individual commercial interest and the demands of their clearing members and end users. But it is time to revisit the policy rationale of compelled DCO registration for comparable and comprehensively regulated foreign CCPs. Under this proposal, non-U.S. CCPs that do not pose substantial risks to the U.S. financial system will have another option for offering swap clearing services to U.S. customers, and that they may request an exemption from registration, as provided for in the Dodd-Frank Act. I appreciate that this may raise concerns with some, but I welcome the public's input to address some of those concerns. However, I would be remiss if I failed to point out, again, that the G20 in 2009 did not expect us to ignore the global nature of the derivatives markets, a fact even more relevant today as U.S. persons increasingly need access to clearinghouses around the world. Contributing to this increased demand is the fact that during the past decade, global regulatory bodies, including the CFTC, and pursuant to G20 principles, have expanded the obligations for market participants to utilize clearing. It is unfair that we would mandate and encourage the adoption of derivatives clearing and then limit access or severely hamper efficient operations of such clearing services. While I'm therefore pleased to see the exemption process advancing, I maintain reservations about the lack of optionality for registered FCMs to engage in the clearing services for their customers at exempt DCOs. As was earlier pointed out by Mr. Bussey, the desire to give clients the option to utilize FCMs is resulting in meager interest in utilizing this option. An unfortunate situation I hope we can address going forward. Once our agency has determined that an exempt DCO is subject to regulation that is comprehensive and comparable to our own, then the arrangement by which a U.S. person may access the exempt DCO should be a business decision between the customer and their preferred clearing member, which may very well be an FCM. We have extensive history in allowing such arrangements for U.S. futures clients at CFTC-registered FCMs to access non-U.S. CCPs. I am certain that the public input will assist us in determining how a clearing structure that works for futures customers might sensibly be extended to swaps customers. While prohibiting FCM participation on exempt DCOs, as we are proposing today, is designed for simplicity, the realities of clearing arrangements and the bankruptcy treatment that applies to them are complex. I am fearful that ignoring that fact may render the exempt DCO option with less appeal than I believe it is due, especially given that we've been able to allow disclosures for foreign futures to serve FCMs and their clients simultaneously at foreign clearinghouses not registered with the CFTC. I'm confident that the tremendous institutional knowledge at this agency, coupled with public input, will enable us to design a workable solution, but it may or may not be the bright line test envisioned by this proposal. Again, I want to genuinely express my thanks to the staff and the Division Clearing and Risk, DSIO, OIA, everyone who has had to spend considerable time with me and all of the folks in on my team over the past few months. The interplay between these proposals has presented particular challenges, and I'm most appreciative of the staff's diligence and responsiveness in addressing our comments and questions. Thank you, Mr. Chairman.
Thank you, Commissioner Stump. Commissioner Berkowitz.
Thank you, Mr. Chairman. Again, thank you to the team. I dissent from the proposal. The proposal would jeopardize U.S. customers, create systemic risks to the U.S. financial system, promote the use of foreign intermediaries at the expense of U.S. firms, and exceed this agency's limited exemptive authority. It would permit, for the first time, exempt DCOs to clear positions of U.S. customers. To accomplish this, the proposal dismisses key protections for U.S. customers and the U.S. financial system provided by the U.S. Bankruptcy Code, the Commodity Exchange Act, and the CFTC's regulations. Enabling U.S. customers to trade swaps and amass large positions in non-U.S. markets without these protections poses risks both to those customers and to the U.S. financial system. The proposal would permit U.S. customers to clear swaps through unregistered foreign intermediaries at exempt DCOs. At the same time, it would prohibit U.S. FCMs that are registered with the CFTC from providing clearing services at exempt DCOs. The proposal thus requires that which the CEA prohibits, clearing by a non-registered intermediary, and prohibits that which the CEA requires, clearing by a registered FCM. The proposal thus creates a bizarro world for U.S. customers where the CFTC does not regulate derivative clearing organizations. Only unregistered foreign firms are allowed to serve U.S. customers, and U.S. customers get none of the protections under U.S. law. The CFTC, however, does not have the superpowers to fashion its own deregulatory planet. It must stay within the orbit of the laws prescribed by the Congress. The CFTC's limited exemptive authority under CEA Section 4C does not extend to instruments that are not subject to the exchange trading requirement of Section 4A, such as non-U.S. swaps traded in markets located outside the United States. In seeking to exempt foreign intermediaries in non-U.S. markets from the registration requirement for FCMs, the proposal exceeds the Commission's authority. Many of the protections for swap customers result from the provisions in the Bankruptcy Code and the CFTC's regulations governing the handling of customer funds at FCMs. CEA Section 4DF provides that only registered FCMs may accept monies to margin-cleared swaps. It also requires FCMs to segregate customer-cleared swaps funds and prohibits the commingling of customer and proprietary funds. The proposal would discard these fundamental swaps customer protections of the Bankruptcy Code. It would free foreign intermediaries from all the regulatory requirements that apply to U.S. FCMs, including requirements providing for the protection of customer funds, financial safeguards, and operational soundness. Absent these protections, U.S. swaps customers potentially face a range of financial and market risks. U.S. customers may find that foreign bankruptcy laws fail to provide priority treatment for derivatives and could include their funds in the general bankruptcy estate for all creditors of the insolvent firm. Uncertainty over the treatment of customer funds held at exempt DCOs or foreign intermediaries, as well as over the portability of open positions at the DCO, could also lead to counterparties to quickly terminate their swaps. The cascading effects on market prices, liquidity, and the value of open positions, and perceived counterparty credit risk could quickly become a systemic event. The losses of one or more U.S. entities due to the bankruptcy of another entity or foreign intermediary in a non-U.S. jurisdiction without equivalent bankruptcy laws thus could rapidly escalate into a more widespread market event involving numerous other persons within the U.S. The proposal would prohibit U.S. FCMs from providing clearing services to U.S. swaps customers at exempt DCOs. By itself, this prohibition would not be problematic, as it is consistent with the Commission's longstanding legal views regarding the uncertainty as to whether the bankruptcy code protects customer funds in such situations. The proposal veers off course by coupling this prohibition with the permission for non-registered foreign intermediaries to provide those same services without any protections to U.S. customers. This approach leaves U.S. customers without any bankruptcy protections and competitively disadvantages U.S. FCMs with respect to clearing in non-U.S. swaps markets. In the cost-benefit considerations in the proposal, the Commission acknowledges, quote, FCMs may face a competitive disadvantage as a result of this proposal, as they would not be permitted to clear customer trades at an exempt DCO. To the extent that their customers shift their clearing activity at registered DCOs to exempt DCOs, or otherwise reduce their clearing at registered DCOs as a result of this proposal, FCMs would lose business. In plain English, this proposal hurts American businesses. The proposal recognizes that this would place registered DCOs at a competitive disadvantage too. The Commission anticipates that some non-U.S. clearing organizations that are currently registered DCOs or that would otherwise apply to register in the future may choose to apply to become an exempt DCO, thus lowering their ongoing compliance costs. A better approach would be to prohibit exempt DCOs from providing clearing services to U.S. customers and permit customer clearing only at registered DCOs. We provide in the other proposal another mechanism to do this with the alternative registered DCOs for non-U.S. DCOs. Use of either a fully registered DCO or an alternatively registered DCO with customer protections would preserve the competitiveness of U.S. FCMs in the global swaps market and largely maintain the bankruptcy and other protections for U.S. customers. On the legal side, the proposal relies on CEA Section 4C for authority to exempt non-U.S. intermediaries that provide customer clearing at exempt DCOs from the FCM registration requirement and the regulations applicable to registered FCMs. Section 4C, however, provides the Commission with limited exemptive authority. This limited authority does not extend to the non-U.S. cleared swaps markets that are the subject of this rulemaking. Section 4C provides that the Commission may exempt any agreement, contract, or transaction from the requirements of the CEA if such agreement, contract, or transaction is, in the first instance, subject to Section 4A, which is the exchange trading requirement. Notably, however, Section 4A does not apply to contracts, quote, made on or subject to the rules of a board of trade, exchange, or market located outside the United States, unquote. Swaps traded in a non-U.S. market and cleared at a non-U.S. DCO appear to fall in the category of contracts, quote, made on or subject to the rules of a board of trade, exchange, or market located outside the United States, unquote. The Commission provides no justification or analysis for asserting that Section 4C provides exemptive authority for transactions in non-U.S. markets involving these contracts. To conclude, the exempt DCO proposal deprives U.S. customers of bankruptcy protection under U.S. law, creates systemic risks for the U.S. financial system, and promotes the use of foreign intermediaries at the expense of U.S. FCMs. It also exceeds the Commission's exemptive authority under Section 4C of the Act. If the Commission desires to facilitate greater access by U.S. persons to foreign cleared swaps markets, a goal which I support, it should do so within the framework of registered DCOs, registered FCMs, and the customer protections provided by the U.S. bankruptcy laws and CFTC regulations. There are avenues to do that, and I look forward to working with market participants and my fellow commissioners on ways to enable those provisions to be more effective. We should not provide customer access to foreign markets at the expense of the protections for U.S. customers and the U.S. financial system. Accordingly, I respectfully dissent. Thank you very much.
Thank you, Commissioner Berkowitz. This proposal would provide a non-U.S. DCO that does not pose a substantial risk to the United States, and only one that does not pose such risk, and one that is subject to comparable comprehensive supervision and regulation by appropriate regulators in the DCO's home jurisdiction, with the option that we've been discussing to be an exempt DCO. Unlike the current CFTC approach to exempt DCOs, the proposal would permit exempt DCOs to offer customer clearing to U.S. eligible contract participants, i.e. non-retail customers, through foreign clearing members that are not registered as FCMs. To be eligible for this exemption, the DCO and the FCM would be required, among other things, to provide clear and succinct disclosure to U.S. eligible contract participants on the bankruptcy protections that would be afforded to them under relevant non-U.S. law. And let's note, swaps trade in only a handful of jurisdictions in the world, all of them major economies with well-developed bankruptcy law protection. To facilitate this proposal, the Commission also is proposing to allow persons located outside of the United States to accept funds from U.S. persons to margin swaps cleared at an exempt DCO without registering as FCMs. This proposal, therefore, is similar to the CFTC's longstanding approach to foreign futures clearing, which provides U.S. customers, including retail customers, with the ability to opt out of the bankruptcy protections afforded under U.S. law to foreign futures funds. If this proposal's approach is hazardous, therefore, then our existing approach to foreign futures must also be similarly hazardous. But I don't think it is. And the approach taken today is, as we've noted, harmonious with the SEC's approach, which I also don't think is hazardous. I believe it is wholly appropriate to permit U.S. eligible contract participants that are institutional and not retail investors to exercise business judgment in this area. In other words, it is appropriate to afford institutional investors the opportunity to weigh the potential economic benefits of accessing products cleared at a non-U.S. CCP through a non-U.S. intermediary that would otherwise not be available to them. And since, as we know, diversification of portfolios is as important a matter in creating systemic health and avoiding systemic risk, then accessing those markets is important. And these are risks that institutional investors in those non-U.S. markets take every day when they chose to clear swaps through those non-U.S. intermediaries at the U.S. CCPs. Some non-U.S. DCOs that are currently exempt from registration may elect to remain exempt or register under the full registration regime with alternative compliance, which we discussed earlier. In either case, they would be able to offer customer clearing, but in different ways. Exempt DCOs would be able to offer customer clearing to U.S. eligible contract participants through non-U.S. intermediaries operating in their markets, while fully registered DCOs subject to alternative compliance would be able to permit customer clearing through U.S. FCMs. In both cases, the CFTC would defer to the regulatory oversight of the primary regulator or regulators of the DCO. Now, as we've heard, some of my colleagues feel that this proposal goes too far. At least one of my other colleagues feels it doesn't go far enough. I feel it's just right, and I fully support the supplemental proposal on exemption from DCO registration. Do any of my colleagues would like to say anything further before we hold the vote? Are we ready to call the roll?
Yes, Chairman.
And the motion is before us. Yeah, it is. Thank you. Please call the roll.
The motion now before the Commission is on the approval of the supplemental proposal on exemption from derivatives clearing organization registration. Commissioner Berkowitz.
No.
Commissioner Berkowitz votes no. Commissioner Stump.
Aye.
Commissioner Stump votes aye. Commissioner Benham.
No.
Commissioner Benham votes no. Commissioner Quintens.
Aye.
Commissioner Quintens votes aye. Chairman Giancarlo.
Aye.
Chairman Giancarlo votes aye. Mr. Chairman, on this matter, the ayes have 3, the noes have 2. The motion is approved.
Thank you, Mr. Kirkpatrick. We'll now have our closing statements, beginning with Commissioner Quintens.
Thank you, Mr. Chairman. I don't have a closing statement.
Commissioner Benham?
Same. No closing statement.
Commissioner Stump?
I have no closing statement.
Commissioner Berkovitz.
No, thank you.
Well, I have a closing statement. My final closing statement, and I really want to begin by thanking my commission colleagues and their staffs. Today's rule proposals, as with most everything that we've done together here at the commission, has benefited from your thoughtfulness and just frankly your intelligence. This will be our last public meeting together, and I thank each one of you for your dedication and commitment to the work of the agency and our markets. It has been truly a pleasure to work with you. We haven't always agreed, as you've seen today, but it's never been disagreeable, and it's always been principled and well thought through. I also want to thank our Commission Secretariat, especially Mr. Kirkpatrick, for his very fine work and keeping me online with the procedure here. Thank you for your fine service to the federal government. My friends, I've had the profound honor to lead this fine agency for 30 months now. And in my time as skipper, I've strived to set the agency off on a smooth course toward a clear horizon under an honest and capable crew. And I hope that my time at the helm will be known for intellectual depth, paradigm resetting, and policy recalibration, but not rollback. I hope it will be considered a time for the winning of hearts and minds amongst market participants in both our agricultural and our financial communities, and with other regulators here in America and on the global stage. And I hope it will be seen as a time of international cooperation while championing American markets and upholding U.S. regulatory sovereignty. Perhaps more importantly, I trust our work will be recognized for its human touch and professionalism, and the building of trust amongst the chairman, the commissioners, and our fine agency employees, but also with our stakeholders in Congress and participants in the markets we oversee. I believe that today the CFTC is known widely to act in a forthright and candid manner, displaying leadership when appropriate, and thoughtfulness and due consideration at all times. And I know that the CFTC's reputation as a trusted and worthy counterparty will be reinforced by the pivotal proposals we've put forward today. If I've been consistent in anything in my time on deck, it's been in asserting the value proposition of the free markets that we oversee. It's the proposition that broad and sustained prosperity generally occurs here in America, and in fact anywhere in the world where there are open and competitive markets, free of political interference, combined with free enterprise, personal choice, voluntary exchange, and legal protection of person and property. And that value proposition is a source of human expression, of human aspiration and creativity. I believe that freedom of choice is a social good in its own right, a moral and economic imperative. Our famous American phrase about life, liberty, and the pursuit of happiness, they're about the freedom of the individual, not just moral or political freedom, but economic freedom as well. Freedom to live in a self-directed manner and conduct honest commerce as one may determine. Under free market capitalism, well-regulated and well-ordered trading activity is a forum for human self-expression and economic advancement. Freedom to act in the marketplace is part of freedom itself. Billions of market actors, following their own self-interest and individual needs, make the decisions that direct the future and not have it directed for them. And I believe it's not the role of the federal government to restrict liberty, but to safeguard it. And it's not the role of market regulation to constrain risk-taking in the free market, but to enhance it. And I believe we enhance free markets through greater market intelligence, sound and data-driven policy prescriptions, and determined enforcement against fraud, manipulation, and market misbehavior. And we also do so through an approach to cross-border market regulation that is risk-based and committed to deference to competent regulatory authorities. It's this vision of market regulation that we've striven to embody and proclaim at the CFTC over those last 30 months. And so as I leave you today, I unabashedly encourage staying the course of free markets, a course that is unmatched in reducing global poverty, sustaining prosperity, and unlocking human potential. No other system in the world even comes close to elevating the human condition as do free markets. So let's not be afraid. Let's stay the course of that future of human aspiration through free markets. And now, with a spirit of gratitude and a heart full of affection for this wonderful agency and my colleagues here, I say thank you and farewell. If there's no other business, the meeting is adjourned.